came up with?
We said we said that it would be a public request.
Okay, but you have to tell everybody what it is, because they might not have gotten around to reading it.
Question one was concerning the rising history of some employees that were let loose because of their rising. And we said that it would be a
Let
public.
loose meaning prior.
I'm sorry.
Prior, right.
Yeah. We said it would be a public request. So we have,
So the questions are those things public records, right? Are the website logs, are they public records?
And we said yes.
Okay.
Who the custodian would be, we figured the security, network security group is, I mean, if anybody was to keep that history, or either the user on their PC or the network security group, because filtering.
Can you hear him?
May be responsible.
Okay.
How long, we have no earth about it because we figured we couldn't produce it anyway. We wouldn't have that history that far back. And the argument against having it, I mean, releasing it or not, like I said, we'd probably say yes.
Okay. Right. Okay, good work. Anybody else who has this question have anything different from that? Everybody thinks it's a public record? Does everybody think that the IT security is the custodian of the record? Anybody have a different
Only if it's
opinion?
captured.
Pardon?
Only if it's captured there, could they be custodian?
If it's captured.
Right.
What does that
That's
mean?
the web filter buffer that he's talking, that's outside the realm of the user.
As opposed to on somebody's personal
Right.
machine, right?
And that's what we were saying, that it's either the user's PC in their cache, or if you have a network security.
How many of you have network security that captures that? How long do you have it for?
7 days.
7 days, 2 weeks, 6 months. Okay, that's a good range. So if it's captured, who's the custodian of it? For purposes of public records.
IT.
I don't know the answer to that question, but I don't think it's IT. So we have this, and this is just a generic, very broad concept that I think is really important to understand, which is why I bring it up. And by the way, this is a question I got from the Charlotte Observer about a month ago. So just so you know, this is not a hypothetical. None of these are hypothetical, actually. So you all maintain and have access to, in some cases, every record that the unit has. And there is a difference between having responsibility for those records in terms of your IT role and being the custodian for purposes of public record, right? So the public records law requires public agencies to provide access to records, and the legal obligation is that of the custodian of the record. And the statute defines the custodian of the record as basically the person who works with those records in their office and has responsibility for those records. Electronic records are just impossible to categorize in that way. First of all, people can have access to that same record from multiple places. So the notion that you're the custodian of the records that are in your office doesn't really work very well for electronic records. By the same token, you also have this security function where you have backup versions of things. And the classic example of how this notion of the legal custodian for public records just doesn't make any sense under the statute anymore is that as the custodian of the records on my computer, I have the right to delete them. If I don't have any obligation to keep them for retention purposes, I can delete those records. Well, I can delete those records and they still exist on the server somewhere or on the backup security. I've done everything I can as the legal custodian of that record to delete it. If we get a public records request, I'm thinking a court's going to say, well, the agency still has that record, and so it still has to be produced. My own view is that I think those records are still my records, even though they're stored in something that you all are responsible for. My way of dealing with IT questions is to translate them into paper versions for purposes of a legal analogy, because courts do things by analogy. It certainly is the case that in many, many cases, it's not a good analogy and you have to throw it out the window and just say we have to make a new rule for electronic records. But in this case, to me, it would be the same thing as saying we have lots and lots of files, they're and there's somebody who operates the warehouse. That's you. If there's a public records request, you're not the custodian of those records. You're the person who operates the warehouse. It's still my record. They're my files. And I would say the same thing about this. So I would say in terms of the custodian, for purposes of public records, I would say those are still that employee's records. Okay? Any questions about that?
So if the record belongs to the employee, do they have to have the ability to destroy it?
Well, you would think so, but the way we have things, unless a court is willing to say, even though you've got to think about it from the standpoint of the public, the public records law is really designed to provide transparency, and our courts interpret it very broadly. So, yeah, I have the right under the law to destroy that record. If nothing in the law or local policy requires me to keep every single email I ever send, I have the right to destroy them. Unfortunately, I don't know, we haven't had a case on this, but I think the court would say, even though I've destroyed that record, because it's available from the agency, it's still fair game for somebody to request it and have access to it. So it's just overrides really the structure of the statute because of the technology. That won't be the first time you'll hear me say that. Yeah.
Well, in this situation where it talks about this rumor that it's been used for potentially the firing of the employee, would that then become information in the personnel record of
All
the
right.
HR role?
Now we're okay. So let's just so the easy questions are that this is potentially a public record. We're going to talk about that in a minute. We've disposed with the question about the custodian. The answer is we don't really know. It's complicated, but I would make the argument that even if they exist in some bulk storage somewhere else other than on that person's computer, they're probably still that person's records. So I want to introduce to you a framework for considering public records that I want you to try and use as we move forward with these questions that I think helps sort out how you get to the bottom line question of do we have to provide this record or not. So the first question, and we'll just apply it to this case, all right? So the first question is, so we've got these records of internet usage that have been requested, okay? First question is there a record that exists that corresponds to the request? This gets at two things. One is, it may be that the record has been deleted or no longer exists, in which case, assuming you have the legal right to delete it, you don't have anything you can provide. This also gets at the fact that sometimes people make requests for information. The other day, I had a request from another Charlotte reporter, and there was controversy about grievances and how they were being handled by the city. So the reporter wanted me to tell her how the city would respond. These are the kind of questions I get. How's the city going to respond to this request? They wanted a list. They wanted to know how many grievances had been filed, and what the outcomes were, and how many of them were against managers. What's wrong with that request from the standpoint of this first question? Do you think the city has a record of how many grievances have been filed throughout the whole city that exists? They could certainly find that out, right? They could do that research and compile a record. But they probably don't have a list, and they probably don't have a list of how many of them are against managers. Might be in a database, possibly. But in general, that's a request for them to compile information. And the public records law doesn't require you to do that. Now again, if you have it in a database and you can query the database, that might be okay. The outcome of the grievance, what's the matter with that request? That's probably going to be a personnel record, right? So the point here is, you really want to stop when you get a request for a public record and say, is this really a public records request, or is it a fishing expedition that requires me to go do research and compile some record that doesn't exist? So if there is no existing record, you have nothing that you're required to disclose. If there is a record that exists that corresponds to the request, which might be the case in this case, for example, if you had a backup and you kept a log of those records, the next question is, was the record made in the transaction of public business? right? Because the public records law provides access to records that are made or received in the transaction of the public business of the agency. What about in this case? Let's just say hypothetically that the internet usage history does disclose a bunch of inappropriate places that these people went at while they were at work. Is that documentation of that activity made or received in the transaction of public business? How many of you think the answer is yes? How many of you think the answer is no? How many of you have no earthly idea? All right. Well, you can rest assured that the press is going to say, well, they did it on work time and they did it using a public computer, and so surely we must have access to that. We don't have a case on this in North Carolina, but there are cases from other states dealing with things like personal email, where they've said that is personal business, it's not public business, and it's not a public record. Now, the distinction that you make is, so if that's the case, the answer is there is nothing to provide under the public records law. There are no records that exist that were made or received in the transaction of public business. And I think that is correct in this case at this point, right, in the analysis. So even, so personal emails, things that you are allowed to do on your computer, even during work time, that don't relate to the transaction of public business, I think probably are just simply not public records. Our courts could possibly say something different than that, but that's the case law pretty much around the country. So the difference is, though, here, that when I say it's not a public record, what I mean is that the public at large doesn't have a right to that record. Right? So who does have access to that record because we did it on work time and we did it on our public computer? Who does? The organization. Right. So the public agency, as the employer, has a right. It is a right that is limited by your constitutional right to be free from governmental search and seizure. So there has to be some policy in place so that you don't have an expectation of privacy in those records. But assuming there is a policy in place, then absolutely the organization, the city, has the ability to view those records and to determine, wow, you shouldn't be doing this on our government time, and you're fired, right? Now, what is the status of that record?
It's in transaction of public business.
It's in transaction of public business because the unit of government might gather that information about you as an employee and make it part of your personnel file. Right? So if, in fact, you have a process in place where you don't keep that stuff, but you do monitor it, and you monitor it to determine whether people are actually spending their time working or not, you've now translated that from something that's really just personal stuff and we don't keep it and we don't care about it to something that the government has interest in monitoring. All right? So now, if we think about it that way and say, well, with respect to these employees who we fired, we actually did monitor them, and we did actually keep that information for a governmental purpose, now the answer is probably yes. Some of those things probably are public records. Is everybody with me? So then if the answer is yes, it was made or received, or in this case gathered and retained for a public purpose, a business purpose for the agency, the only other question is there an exception that applies? Because if you get to this stage in the analysis, pretty much the answer is going to be you have to disclose. So if there's no exception that applies, the record must be disclosed. So those are two questions you can ask to make sure, is this really a proper question? Is it really a request for a record, or is it not? And is it a request for a record that actually is a public record? So at this stage, then, we say if that's the case, the next question is there an exception that applies? There are two kinds of exceptions under the statute. There are some exceptions that prohibit you from releasing records, and there are other exceptions that say, well, you don't have to, but you can. So the public doesn't have a right of access, but you're not prohibited from releasing them. So in this case, I've already kind of given you the answer. What do you think the status of this record is? Is it a public record or is it not? Right?
The HR, it's going to HR and it's part of the personnel.
Right. So what I told the reporter, I hope I'm by the unit. And if they've been gathered by the unit, it's probably for a personnel reason, which means that they're confidential. Needless to say, the report was not happy with that answer, but if there is an exception, you have to know whether the exception is one that prohibits you from releasing it or allows you to, and then you have a decision about whether you want to release it, and whether it's an exception that goes to the whole record or whether it's just a matter of redacting the record and you have to release it. And that's at the stage where you want to consult with your attorney. Actually, the first stage is where you want to consult with your attorney, but especially in that last stage where you're trying to figure out if an exception applies and what you can release and what you can't. Any questions about this scenario? Yeah.
Not a question, but maybe a comment.
Yeah.
I think there were some bills in the General Assembly the last couple of years about changing that so that the personal records could be disclosed. And luckily, it never really got.
Yeah, I mean, it comes up every once in a while. They did in 2010 expand the information in the personnel file that is now public. But I haven't seen any real specific attempts to make non-public related. I mean, you could easily legislatively say anything that's made on a government-owned computer, is public. But I haven't seen very much. Yeah. Well, it can happen any minute, so it's a good thing to be aware of. And then, of course, the flip side of that is that when you're using your private devices, the assumption is that records that are involved in the transaction of public business made on a private device or a private account is public as well. So that's the flip side of that. So there's a question back there somewhere? Yes?
So in a situation like that, if it were part of the personnel records that were public, but they're, let's say, disciplinary action or whatever, would the disciplinary action be the record, or would the evidence of the disciplinary action be the record?
Well, there could be records that relate to both the evidence and the fact that the disciplinary action was taken. What the personnel privacy statutes do, so the information of what's public about all of us as public employees is in a separate statute. It's not in the public records law. There are separate statutes in 160A, 153A, and 115C that list specific information about employees that can be released. And so you know your salary and that kind of all that stuff. So what it says about disciplinary actions is the information that a suspension or a demotion or a promotion, it's just the information of when it happened and what it was, but not the reasons. So the justification for and all that documentation is not public, but you can say, please give us give me a list of all the people who've been suspended this year. That's fair game. You can actually be required to do that, but not the reasons. The only time the reasons can be public is if it's a dismissal for a disciplinary reason. The statute as of 2010 requires the agency to release the notice of final dismissal, setting forth the reasons for the dismissal. But that's the only place where the underlying documentation is public.
So in your scenario, you could disclose that they were fired for going inappropriate sites, but you wouldn't have to give the law and say which inappropriate sites they went.
That's right. None of that detail. That's right. Yes?
What if you didn't tie it to the person? The request that came in was to the HR department for a list of any records that they have about inappropriate sites, but they didn't tie it to any individual.
Even if the request, I don't know if everybody heard the question, what if the request came in, but it wasn't tied to a particular person? Even then, that information is going to be confidential. So regardless of whose file it is, if the only reason that the unit of government has retained that information is in connection with a person, an individual employee, it's still going to be confidential. Now, if they just keep that information and they haven't gathered it for any personnel reason, I still would maintain it's not a public record because they just keep it because they back everything up, just like all of our personal emails. Yeah.
I reply to emails on my personal phone that are work-related. How does that play in?
So how that plays in is that those are public records unless there's an exception that applies. So again, there's nothing in the statute at all that dictates that part of being made or received in the transaction of public business has to do with how it was created. Again, if I have paper at home that I bought, and I use my own pen, and I write a letter to Mike saying Shannon needs a raise, you know, that's a public record. Actually, it's probably a personnel record. But, you know, the fact that I use my own paper and my own pen doesn't make it not a, so that's the way I'm very simple-minded. Yes?
What about texting?
Same. Same. Okay? All right, let's move on to number 2.
Can I ask a quick question?
Yeah.
How many of you here have a social media policy in place that deals with Facebook, things of that nature, specifically with public records?
I don't know how they address it, I just look at the policy.
And what are you getting at with that in terms of your
Generalized question.
Yeah, no, but I'm interested to know what policies you have about retaining comments
It's
and.
retention, it's who's monitoring it, how long are you keeping it, those types of things. Because it goes right along with the texting.
Right.
It is a question of who is responsible for that, how long do you keep it for, what's the relevancy. And I know the question you were just asking about with personal email, well, not personal email, but your device, the big kicker for a lot of IT people is, I don't want to carry 3 or 4 devices. So I have everything rolled onto my personal.
Right.
So the perspective I've always taken is, look, it's company email, but it goes through that exchange box. Which means if you ask me to turn my phone into you, I probably won't unless you force me to. Because the only thing that I have on there is corporate email, but it's already being backed up off that exchange box. And that's a sticky one for IT people.
If it's being backed up, that's great, that's fine, you have everything. You have all the private and the public, right?
No, it would be strictly my private.
Well, unless you're
Or, excuse
doing,
me, strictly.
unless you're making occasional personal emails on the corporate account, some people do. Yeah, and again, it's really important to understand that what determines whether it's public or not is the content of the record. So the medium does not matter. And we'll talk about that when we get to question number 3. Let's get to that question number 2. Any tables, is there a table that did number 2 that would like to summarize the question and then tell us what you came up with? I'm sure there is. Thank you.
So you have an engaged citizen who has been known to have posted her own information about things that she finds out about the city. It's a pretty good manager. And she wants the manager's original PowerPoint presentation in its native format. And your policy is that you give out this kind of information in PDF format, which we all know is not as easily modifiable as PowerPoint. And you want to release it in your PDF format. Or are you under any obligation to produce it in PowerPoint as requested? And I think initially we all agreed that, and I think this is, that we probably need to release the PowerPoint because, first of all, it's in a format that exists and it's in the record that already exists as evidenced by the presentation that was given. So you probably really can't do that. You really can't withhold it because of the risk of alteration, you know, so obviously.
Great, that's a perfect answer. Did everybody hear that? So the question here, oh, and I'm sorry, on the last question, I wanted to mention metadata. Sorry, one just backtrack to the last question. It's arguable that that information, that record that was being requested in question number 1 is metadata, in the sense that that is information that's automatically created by the machine, right? And there is possibly an argument to say it's not a public record because it's metadata. It's something that the machine created. I think it's harder to make that argument because you're retaining it and you're saving it and you're using it for a business purpose, if that's the case. But if it just happens and you don't save it and it disappears into the ether eventually, there is this whole open question about what the status of metadata is under our North Carolina Public Records Law. And Karen Melanzi has, my colleague, has several really good blog posts on our blog that talk about that in terms of cases from other states and from the federal government. I think it's pretty likely that if you maintain some of this information, again, backed up in some way, and it still exists, our courts are probably going to say that it's public. And I think that's the trend, at least for things like email addresses that are embedded. I would think probably that these logs of internet usage, I would note that there is actually a schedule in the records retention schedule for this information. And I've pasted it in here. If you look, individual program usage files and records of use of the internet by employees. But that's not binding on a court, but the state agency that has legal responsibility for telling us what records we can destroy and what we have to keep has included this, which is going to be some evidence that there's an assumption that it's a public record. And again, you can see it's destroy an office when administrative value ends, which means if it disappears and you don't back it up and you don't keep it, there's no obligation to keep it under the law. So that's important to know. But again, if it's maintained as part of the personnel file, then it becomes a subject to the personnel file retention, which is like pretty much forever. Right? So again, it can disappear, government related or not government related. If you don't maintain it, that's perfectly fine. But once you grab it and use it for some purpose, then it becomes subject to that retention requirement. All right, back to the case at hand. So, medium versus format. I never thought when I went to law school I would be thinking about these things, but with Shannon's help, I'm learning how to tell the difference between medium and format. So, the word medium is important because the public records law specifically says that the public agency is obligated to provide the record. The right of access is either inspection or a copy. And the statute says as to a copy, you have to provide it in any medium in which it is requested if you have the capacity of preparing it in that medium. So does that mean they can come and say, I want your entire database, but I want you to reformat it so that I can use it for the purpose that I want to use it for? No, because that's not a medium question, that's a format question. I learned that from Shannon. Medium, I think, probably means things like paper, electronic, I want it on a CD, I want it on a flash drive. To me, that is medium. And that's what the law requires you to accommodate. You can charge them if they want it in a medium that costs you something. If they just want it emailed to them, you probably can't. Format, on the other hand, is all of the stuff about how the program works or how the information is displayed and all of that kind of stuff. And there's no obligation to reformat under the statute. There is some interesting developing case law on that. There's a case, I haven't checked it recently, but the last time I looked at it, involving GIS systems. And to the extent that increasingly you smart IT people are figuring out ways to create data and information that can only be accessed with the program that created it, right? I'm probably not explaining that in the best way, but take GIS, for example. There's all kinds of information that's in a GIS system that you basically have to have the GIS software to be able to really access. I mean, you could print it out or you could create it in some static way, but people have been arguing, there's a case out of California where basically they said, look, this is designed to be an interactive information database, and I can't use it. I don't have access to it fully unless I have the software that runs it. And the court basically agreed with that. So there's this layering of the actual software where you don't really have the record unless you have the software, and it's getting kind of complicated to figure out how you provide access to that. But in general, under our statute, you don't have to reformat something or change it in some way according to a public records request. By the same token, however, this table was completely right. The flip side is you can't give somebody a restricted version of a record that you actually have and can provide in native format. And so the message here is, I know that we worry about what somebody might do with our records. They might change them and pretend that we made it the way they made it. And that's life. You have to deal with that. You can't really ask what they're going to use it for, and you can't, even for the most noble reasons, say, we're afraid you're going to do something bad with this and make us look bad, So we don't want you to really have the ability to manipulate the record. You just don't have authority to do that. And the bottom line is, you have to give them the record that you have. And the record that you have is a PowerPoint presentation in native format, and I think that's what I think. Again, no case law on that, but I just read that as this is what I think the statute requires. Any questions about that? Yes?
Which version of it? Since I did my presentation and I have 8 versions of that particular PowerPoint, which version do I need to give them?
When you say you have different versions, you mean like draft versions?
Yes.
Well, in this case, I think it's the one that was presented at the meeting. And probably, for those of you who post that stuff, it's probably going to be posted on the web, probably in PDF, which is fine. You can, when you decide to post it, you can put it as a PDF. But if they want that version native format, that's the one you have to have. Now, if they asked for all of the drafts, anybody know what the law is on drafts?
They're not allowed, we don't have to do those.
That would be nice if that was what the law is. That's what we wish the law would be. There's actually a case, it's a North Carolina Supreme Court case that specifically says that draft documents, once they are sort of out of your computer and distributed to somebody, if they never went anywhere else, it's possible that you might be able to withhold them, but draft documents that you have retained, that you still have, are fair game. So, if you have 17 versions of that, delete them. The records retention statutes do not require, the provisions do not require you to keep them, but again, the rule is, even if the records retention requirements allow you to destroy them, if you haven't done so and you get a request, you have to provide them.
But that's requesting something that is not known to actually exist, though.
Well, they don't have to know it exists to request it.
It could be the state of presumption.
They can just say, if you have any of these records, as long as the description in the request is sufficient for you to identify whether you have it or not, that's all that you have to have.
But isn't there, though, from draft 1 to final version, a recognition that what's requested may or may not be close enough to even be considered a draft of that, so it's not available? I start out with my first draft with just one line, and
At some point, you have to make a decision about whether
it's
it's a draft of that record. If it started out, if it ended up being that record, and that's how it started, it's probably a draft of that
which
record.
may not have any resemblance to the original because of
So be it.
change of opinion.
So be it.
Does this also cover something like shadow copies where you're constantly
Well,
doing point-in-time copies of something of a user's document? I don't know.
Yeah, we don't know what you all have on us.
Or-
It's always
They don't think the NSA has.
We don't know, we don't want to know. I mean, again, theoretically, any record that you create in the transaction of public business is a public record unless an exception applies. Our court has said there is no exception for drafts. They said that in the 1980s, and the legislature, if they wanted to make an exception, could have, and they haven't. So drafts are public record. That also means that track changes in documents, if they're still there, could potentially, again, that's metadata, we don't know, but could potentially also be discovered.
But also, like, if you were meeting to do a PowerPoint, like a group, and collaborating on it, like writing notes, I mean, are those also, if somebody requested.
Is it a record? Should we go back to the framework? Does a record exist that corresponds to the request? That's the first question. The second question is, was it made in the transaction of public business? The third question is there an exception applied? Yeah.
The techies around here, when you delete something, something's not deleted.
Right.
Are we?
Even I know that.
Are we required to recover that if requested?
No,
Normally the master boot record, we just change the first letter in the
If
master.
I
boot
delete it
record.
off my computer, but now it's in my deleted box, I think it's probably still a public record. If I delete it and it's on the server, I think it's probably still.
It's
But if
deleted, but
it's-
it's still on the hard drive in a deleted format. Are we expected to recover that if it's specifically requested to do
I
so?
don't think so, but I don't know.
If there's a subpoena, yes.
Well, that's a separate thing. If it's in litigation.
Right, yeah, criminal.
Talking about discovery, that's a different thing, because you have obligations to maintain information and you can be sanctioned for deleting it. But I don't think we have to recover.
But again, the custodian of the record wouldn't know how to do the recovery anyway, so they're taking custodianship at that point if they start trying.
Well, I mean, I can get IT to come help me figure out how, actually, I've learned how to do that a little bit, because I do that all the time. But I mean, the fact that I, as the custodian, don't know how to get it off my computer is not gonna be the legal thing, but it's gonna be, the question is gonna be, you know, somebody would, that's a case where I would say somebody would have to come back at you and say, you know, it's really getting into forensics at that point.
Right.
And I think somebody would have to have some inclination that there's a reason to, court would have to have some inclination that there's a reason to make somebody go look in, you know, the computer to get recoverable documents. I doubt that, I've never seen a public records request, a public records case go to that length. Discovery, absolutely. But that's when, you know, there's information that's relevant to a case and you can be sanctioned for having destroyed it. Okay, so can't protect our records by PDFing them, and can't control what people do. That's the takeaway. Any questions about that?
I'm not sure if it was the same question Gentleman across the room had, but the notes on the bottom of the PowerPoint.
Is it part of the record?
Well, I mean, it says that where it was presented to the council. So those notes weren't really presented. They had the picture up here, but they didn't
But
have
the
notes.
request is for the record, all right? The request is for the record. So the request isn't, I want to see what they saw, I want that record. And so if that's part of the record, that's going to be part of what you have to provide. Yes?
If it was something really sensitive and you wanted to protect it, could you make it a PDF before you presented it?
Well, the question is going to be whether you have anywhere in the general custody of the unit of government a version of it that is still in native form. If you do, I mean, unless you've deleted all of the other versions of it and the only one you have is a PDF, I don't think you have to back it out, but I'd be surprised if you didn't have a version of it that's in native form.
So the policy in this place is irrelevant, according to
The what?
the city council government's policy that they had in place of giving out PDFs is.
Well,
It's
so
irrelevant.
it's perfectly fine to have a policy that says when we post them, when we provide them to people, other than through a public records request, it's perfectly fine. And if they don't ask for it in native format, I think it's perfectly fine to have your first shot be, okay, here it is in PDF. And then if they say, oh, no, I want it in native format. So I think it's fine to have that policy. You just have to know that if somebody specifically requests not PDF and you have it, you have to provide it. All right. Let's talk about question number 3. Any tables who did question number 3 want to jump into body cams and video cams? How many of you are in a jurisdiction where they're using body cams? Law enforcement. Okay, good. The question, this is a question about a request for, well, actually, just in general. A lot of people are dealing with policies on these things, so I just want to jump right into how do we deal with public access to this. You know, the whole, you know, groundswell of enthusiasm for vehicle cameras and body cameras is transparency. The whole idea is people need to know what happened, right? And so the assumption that a lot of people are making is that there will be a way for all of this recorded data to be provided to the public. So this is an interesting question. So anybody want to volunteer what you think the status of these records are? Let's try using the framework, okay? Does a record exist that corresponds to the request? So if somebody requests the video data from either the dashboard cameras or the body cameras, everybody agree that there probably are records about that? Okay, we'll talk about the retention requirements in just a minute. Okay, so the answer is yes. Is it made in the transaction of public business? I would say yes, unless, for example, they leave it on, you know, when they stop for donuts, you know, lunch, or lunch or, go to the bathroom or whatever it is. There might be some of that that would be captured, unintentionally, although there are policies that actually require them to keep it running. So, you have to, because people are concerned about them turning them off at, inappropriate time. So, anyway, let's just assume that they are made or received in the transaction of public business. So as we know, then the next question is only, are there any exceptions that apply? Anybody have any thoughts about what exceptions might apply?
Juvenile.
Right, okay. Records about juvenile might be confidential. What else?
Part of the investigation.
Right, it's a law enforcement record. So our statute has a really, really broad exception for law enforcement records. It's broad in the sense that it really relates to anything that was created in the process of apprehending or preventing or investigating a criminal, anything that's enforceable under the criminal laws of the state. So even if no crime is committed, those records are still protected. Now that's an exception. Remember I said there are two kinds of exceptions. One where you're prohibited from releasing. The other is where you are not required to release the information, but you can. The criminal investigation statute is the optional kind. It's not confidential. Now, in a juvenile case, it might be, but in general, that information can be released by the unit of government, by the law enforcement agency, in its discretion. So that's sort of a half and half kind of situation with respect to release. What other exceptions might apply?
Medical.
Homeless and they're 40, they're not in a public place, and that's not good.
Right, so the point is, and this is actually the position that the ACLU takes, which is that there are many of these situations that involve people in private situations, private homes, private offices, private vehicles, and that people have an expectation of privacy there. It's probably not the case that there is a legal exception that prohibits the release of that information. But it is a big concern that the ACLU has, and their advocacy has been, we want these, I'm going to open this up. We want, the ACLU wants people to just basically, to want the agencies not to release that information. But there's no exception in our statute that would say you can't release it if it's in someone's home. But that's a consideration. What else? Note that I've said, what are the purposes? When we look at, so this is a really important, this is going to be really distracting, but we'll get through this. Video camera data and body cam data is not content. It's like email, right? It's a medium. It's a form of the record. So you can't know what its status is under the Public Records Law without knowing what's on it, right? And how it's being used. So it's just like email. There's no rule that says all email is public or all email is not public. You have to know what's on it to know whether it's public or private, right? So here, we've said, all of these policies say they're for law enforcement purposes, but they also say they're to evaluate the performance of the employee, right? So a big thing that the public wants to know is who shot first, or did they ask them to, drop their weapon before they shot him, or that sort of stuff. So personnel file, right? Some of this information is going to be used specifically to evaluate and review the performance of the law enforcement officer. And we have an AG's opinion saying that even an internal review document is confidential for personnel records. So it's a law enforcement record, which means there's an exception that allows them to restrict it. Any footage or data that they retain with respect to the individual employee, law enforcement officer, is going to be confidential, absolutely confidential, can't be released without a court order. So we have this situation, and then training, some of this may be used for training, that would be public. Use it for training, could be public. So the blog post that I wrote really emphasizes, look, if folks are going to have these policies, it's going to be huge frustration, and you're going to get lots of pushback from citizens who are saying, we want, the whole reason to have these is to make them transparent, and so there may be some need for some legislative fix for this. But right now, you hear about this stuff nationally. Other states have different public records laws, and some of the states have faced this exact situation where the court said, no, this stuff is confidential, and the legislature went back in and said, no, we're going to make it public. But it would change, it would requires a change in the law for these things to be public, pretty much. So just so you know, and there's a blog post on that. I have written out links, titles of blog posts that you can link to get more on some of these topics. So these are definitely public records. I think there are exceptions, and at least in the case of personnel, probably they are not going to be allowed to release, agencies are not going to be allowed to release them. We don't have time really to talk about how your policies are written. I will note that my blog post links to a really good study that was done that has recommendations for what kind of policies you should have about release and use of these. It's a really good project. Last question, request for emails. And the records retention, there are record retention standards for the mobile unit videotapes. There aren't any for body cams, but a lot of people are using something close to the 30 days for the body cams. The ACLU wants them to be short because of the privacy issues. They want people to not maintain them, and they're very concerned about people mining them for data. So if you keep them for a really long time and you have all this information about bystanders and other people and where they were, so there's a big pushback with that. So it's something everybody thinks everybody should be doing, but it's kind of controversial. Responding to requests, real quick. I'm going to have this request, question number 4. And this gets back at the thing that we were just talking about, this issue about personal devices. And so you have these wide open, I want all the emails about this controversial zoning thing. So where do you start? Anybody have any of those? Who coordinates this stuff? First question. In your units, who coordinates responding to an email request like this? How many of you are the first stop?
I have a question, because I'm a little one-man shop, and I have requested all the managers' emails.
Right.
And it would be almost impossible for me to set aside the time.
Yeah, but somebody will probably have to do this, right? If you get that request. Well, what about some of the other folks? How many of you have sort of a PIO person who handles that, or the clerk? Clerk. So it's perfectly fine for that to be coordinated internally by someone, and I think it's a really good idea to have one person who takes the request. Technically, the law requires the request to go to the custodian of the record. I think it's perfectly fine if the person is willing to say, I'm going to file it with the clerk, and then it will get sent to that person. The press is very hot on the idea that you can't have a gatekeeper, and if they want to make their request directly to the custodian, they have the right to do that. But basically, you can't have a coordinated effort. I strongly advise that. You have somebody who reviews them from a legal standpoint. So you could probably not, with too much difficulty, find all the records that have the manager's name on them. But then the question is, then what do we do with them? Because some of those are going to be personal, not public record. Some of them are going to be confidential. So somebody has to go through and do that analysis. It's always nice if it can be a lawyer or somebody who knows something about the law, so that they don't give away all the personal emails when they don't really have to. And what about personal devices? How many of you have board members that use their own private iPads or phones to do? And how willing are they to help you find these records? I remember when this first started and when I was first doing these training, and everybody said, well, you have to really train them so that they know that the stuff that they're creating is public record. And I want to just say to you, we have succeeded. They know. It hasn't changed their behavior at all. I mean, I do these trainings now, and I give them quizzes, and I say, true or false? Records related to public business on your private email account is a public record. And they all say, oh yeah, we get that. Great. I do not have a solution to this problem, but I hope you all know that that is the law. How many of you have dedicated government accounts that you make them use or that you ask them to use? And how many of you have dedicated government-owned devices that you ask them to use? Okay. Still doesn't prevent them or us from creating business records on our private devices. Now, a couple things about that. Many of those things are things you're not required to retain. And if you're not required to retain them, and you delete them, you don't have a problem when you get a request. If you're not required to retain them, and you don't really delete them, and you still have them on your devices, you're still going to have to copy them. And sometimes somebody will make a request, and they already know that you sent that email because they have a copy of it for the person who sent it to. And you say, I don't have that email. And they say, ha, I got it. Well, not necessarily. Maybe that you deleted it because you didn't have any obligation to retain it. But it is also going to be important for all of you to have systems in place so that people understand that when you get a request like this, which is absolutely fair game, that you have a way of saying to these folks, you need to search your devices. I don't think there's much else you can do. Yes?
Doesn't the town of Cary require their elected officials, if they use personal accounts, that they have to forward all public records to the clerk for management? I think they're the only town I've ever heard that actually does that.
Yeah. Well, but I know a number of people who ask that.
Yeah.
Again, there's no way to enforce it. There just isn't, it's an honor system. So, and again, I just wanted to emphasize when you get a question like this that you're not just because you physically or virtually or whatever have responsibility for those records doesn't necessarily make you the custodian. So this obligation goes to the custodian. If a board member says, I simply refuse, I'm not letting anybody look at my iPad, the liability is theirs personally. Yeah.
The cost of redacting, we take those emails and turn them over to our legal department and they who the contract, and they have to go through and redact.
Wow, that is the hardest question there is. So the last point, what can you charge for? Typically what you can charge for is the copies, not the time it takes you to find them, redact them, review them. There is no authority under the statute to charge for any of that time. This is a really nasty looking slide, but this is the language that some people are now using to charge for the IT time, to charge for the time it takes you to literally retrieve those. We have no idea under the law whether that's what this means. It talks about the cost, the information technology, goods and personnel time that it takes to produce the record. No idea what that means. The state is charging for that, gotten a little heat from the press for that, but they're still doing it. They're charging for the agencies, for the state IT agencies' time that they have to pay for as an internal enterprise. The hardest thing is this contracted attorney, because on the one hand, if it's Brian and that's what he gets paid to do, they can't charge for that. It doesn't seem to me, just not as an advocate, but just from an equity standpoint, that if I happen to make a request to you and you happen to contract out for attorney services, I have to pay for that. Even though it's not an expense you would have otherwise incurred, it seems to me that's part of the attorney's job. The city is required to have an attorney. I'm uncomfortable with the idea that just because you decided to contract out for good reasons, following Shannon's last talk, that's something you can pass along. So similarly with IT, if you have to have an IT specialist come in, I don't know. But this is a window where you have these huge electronic records requests. There's some possibility to be able to recover some of that time of just retrieving the records, but probably not authority, at least in my view at this point, to charge for the time it takes to review them, redact them, decide what to provide them.
Isn't there specific language that says you can't charge for the redaction of commingled data?
Well, what it says is there's a provision in the public records law that says if you choose to combine confidential with non-confidential information, you can't charge to separate it. And I think that's really getting at, sort of being sneaky and trying to combine a database or something like that. But I think that would be what somebody would cite to if you tried to charge them for redactions. So, all right, it's time. I think it's time for you guys to.
Does everybody here know where the blogs that she referenced are located?
No.
Okay.
I realize that.
It's really easy. Go to the front page of the School of Government's webpage. It's sog.unc.edu.
Yeah,
On
we're
the
not gonna-
right-hand side, there's a list of blogs, And the local government law blog is Codes Canons, and it's the first one on the list. There's other blogs that are really good too, but we blog about lots of stuff, lots of public records and other stuff, and it's searchable and it's free, and you should subscribe. Sometimes technology
I'm
is
not
not
trying
as
to go on
fast
that
as
route.
talking. Front page of the School of Government, Codes Canons. Thank you,
Thank you, Fran.